So, this is my court case video on Reno versus Condon, and so some background information. Starts off at the DMV, or the Department of Motor Vehicles, and at the DMV, if you're a driver, it requires you to give them all your personal information, such as your legal name, your date of birth, your social security number, and sometimes even your medical information. So in the year of 1994, Congress found out that some states were selling these information to private organizations or private entities for a big price. So in turn, Congress decided to make an act not allowing states to sell these information out without the driver's consensus unless under certain circumstances. Also controlled how the people that have the information could use or disclose the information. The act was called the Driver's Private Protection Act. Many states did not like this idea and wanted to continue selling the information. One of these states was South Carolina. And in South Carolina, the Attorney General of South Carolina during that time, Charlie Condon, decided to sue the block enforcement of the act, stating that the act violated the 10th Amendment, which basically states that power has not given the federal government, is given to the people in the states. This would include the DMV. Both the District Court and the Court of Appeals declared the act a violation of the 10th Amendment. And later on, the U.S. Attorney General at the time, Janet Reno, petitioned the Supreme Court for review, and the Supreme Court agreed. And during the hearing, they decided that the Driver's Privacy Protection Act is a proper exercise of Congress regulation of interstate commerce under the Commerce Clause. Chief Justice William H. Rehnquist states that Congress may regulate the state's participation in interstate commerce but may not require states to enforce federal programs. So the impact of the case, first of all, was that it took some power away from the states, more in the federal government. And although the act is what stopped states from sharing our private information records and protecting our privacy, the case solidified and basically protected our information. And the biggest part of the case is that the federal government can regulate the states as long as it doesn't require the states to enforce any federal program. And if the states had made the opposite decision in the case, then our information would not be safe, and the state can still sell it for large amounts of money. Not only that, but states would basically have a huge amount of power over the federal government, since it states that in the 10th Amendment that anything not enforced in the Constitution will be left to the states and the people. So basically giving all power to the states. And I believe that the court made the right decision because as a citizen, I feel like I don't have to do with the government, and I wouldn't want other people seeing my information, regardless of if it means harm or not. I don't see how having this act would benefit the people, and rather it is just the states and private organizations that benefit or profit from these information. Although it does go against the 10th Amendment, I don't think that it should go over the protection of privacy. I think the fact that states are selling private information is an invasion of privacy itself. It's like the theory that the government is always watching through webcams and personal devices, but on a smaller scale. These things usually won't affect one's lifestyle, but it's something where I would rather keep private. And on a larger scale, this also allows federal government to have more control over the states, but still letting the states enforce what they want. And the only reason why I kept that part so small was because, in my opinion, I feel like those things don't have too much of an impact on my life personally, so I don't have too many experience in how it would feel from that point of view. Thank you.